दोस्तों नमस्कार। 1 मई को सुप्रीम कोर्ट ने डाइवोर्स के मामले में एक लैंडमार्क जजमेंट दिया है, जिसके हिसाब से अब सुप्रीम कोर्ट डायरेक्ट बिना लेट डाउन प्रोसीजर फॉलो किए आर्टिकल 142 में जो डाइवोर्स दे सकता है अगर सुप्रीम कोर्ट को लगता है कि जो शादी है वो अब दोबारा से उसमें कोई संभावना नहीं है, इरेट्रिबल हो गई है वो। तो मैं आपको ये जजमेंट पढ़ के सुनाता हूं। इससे पहले आपको थोड़ी सी जो न्यूज आ रही है वो बढ़ा देता हूं। सुप्रीम कोर्ट ने 1 तारीख को बोला है कि अगर मैरेबल इरेट्रेबल ब्रेकडाउन है तो हम उसको अपने एक्सटर्नल पावर के हिसाब से डाइवर्स दे सकते हैं। अब इसमें होगा क्या कि जो 6 मंथ का नॉन कूलिंग पीरियड है डाइवर्स का हस्बैंड और वाइफ के बीच में, वो खत्म हो जाएगा। सुप्रीम कोर्ट ने बोला है कि we have held that it is possible for this court to dissolve marriage on the ground of irretrievable breakdown of marriage. इंदिरा जयसिंह जो पटिशनर की तरफ से एडवोकेट थी, उन्होंने बोला है कि ये मैरिज लॉज में स्वीपिंग रिफॉर्म्स लाएगा। जब जजमेंट अनाउंस हुआ उसके बाद में इंदिरा जयसिंह ने ये बोला था। The provision in question gives the complete court power to do complete justice by enforcement of decrees or orders in any manner pending before it. The court said the mandatory waiting period of 6 months to grant divorce through mutual consent can be waived off, but it is subject to certain conditions. Advocate Jai Singh said the Supreme Court moved away from the strict theory of fault-based divorce and divorce based on irretrievable breakdown of marriage and held the order. The court said divorce can be granted even when one of the parties oppose the decree. This discretionary power is to be exercised to do complete justice to the parties, wherein this court is satisfied that the fact established shows that the marriage has completely failed and there is no possibility that the parties will cohabit together and continuation of the formal legal relationship unjustified. Under Section 13B of Indian Hindu Marriage Act, which lays down the procedure to get divorced by mutual consent, both parties need to finish 6 to 18 months of cooling period from the date they present their petition for divorce. The waiting period before court makes possible a decision that can allow the parties to withdraw the plea and allow reconciliation. The judgment came in a 2014 case filed by in the Supreme Court by Shilpa Sailesh and Varun Srinivasan, who sought divorce under Article 142. The court listed out factors to determine the irretrievable breakdown of a marriage. These include the period of time the parties cohabited after marriage, nature of allegation, and that the period of separation should be anything above 6 years or more. The decision comes only days after the court said in a separate hearing that the irretrievable breakdown of marriage can amount to cruelty under Hindu this and can be ground of divorce. अब मैं आपको ये जजमेंट शेयर करता हूं आपके साथ, आप उसको देखिए। कुछ 60 पेज के आसपास का ये जजमेंट है। और इस जजमेंट के रिलेवेंट पैरा को मैं पढ़ने की कोशिश करता हूँ, इसको आप समझने की कोशिश करो। देखिए, ये है, ये जजमेंट रिपोर्टेबल है in the Supreme Court of India Civil Original Jurisdiction Transfer Petition Civil Number 1118 of 2014। तभी भी 9 साल लग गए। शिल्पा शैलेश वर्सेस वरुण श्रीनिवासन, ये है। इसमें है ट्रांसफर क्रिमिनल 96,339 382,468 and transfer petition 1481 to 14 of this। संजीव खन्ना साहब ने इस जजमेंट को लिखा था, उनका नाम लिखा गया है। द इशू बिफोर द कॉन्स्टिट्यूशन बेंच एज एनुमरेटेड बिलो arise primarily from the order dated passed in TP number so and so Niti Malviya versus Rakesh, where a bench of 2 judges have doubted the view expressed in Anjana Kishore and Puneet Kishore and Manish Goyal and Rohini Goyal that this court in exercise the power under article this cannot retrieve or waive the period of 6 months for moving the second motion as stipulated in subsection 2 of section 13B of Hindu Marriage Act, noticing that this court, some high courts and even family court in some states have been dispensing with reducing the period of 6 months for removing the second motion when there is no possibility whatsoever of the spouses cohabiting. The following question was referred to a three-bench bench for a clear ruling and further guidance whether the period prescribed in subsection 2 of section 13B of Hindu Marriage Act 1955 can be waived or released by this court in exercise of jurisdiction under article। ठीक है, दूसरा क्या बोल रहे हैं ये? However, the question was never decided since TPC 899 after was rendered infructuous as the parties subsequent to the order of reference have dissolved their marriage by mutual consent. In TP 118 of 2000, Shilpa Shailesh versus Varun, the bench of 2 judges by the order dated 6/4/2005 issued notice to the Attorney General for India for addressing the argument on the following issues. The scope and extent of power of this court under Article 142 of the Constitution insofar as dispensing the period of notice under 13B of Hindu Marriage Act is concerned. The extent of government with regard to statutory incorporation of irretrivable breakdown of marriage as one of the conditions of grant of divorce. Any other incident and ancillary issues that may arise may also be addressed by the Attorney General. Attorney General of India in paragraph 5 of his written submission has suggested 2 additional questions of law which read this. In view of the decision of the High Court in the above case, the view of the High Court that divorce can be granted on the ground of irretrievable breakdown of marriage even in the absence of such ground being contemplated by the legislator may require consideration by the Constitution Bench. Similarly, the issue as to whether period prescribed in subsection 2 of the Hindu Marriage Act can be waived or reduced by this court in exercise of jurisdiction under 142 of the Constitution also require consideration by the Constitutional Bench. Was effectively disposed of wide order dated 6/5 dissolving the marriage by grant of divorce by mutual consent with the 2 judges bench exercising jurisdiction under Article 142 of the Constitution of India. However, in view of the conflicting ratio of the judgment of this court on the applicability of the power and jurisdiction of this court under Article 142 of Constitution, the 2 judges bench of this court deferred the transfer petition to remain pending for statistical purposes and permitted the following question of law to be decided by 3 judges bench. Notwithstanding the above order passed by us for the purpose of statistics, the present transfer petition shall remain pending as we are of the view that an issue of some importance need to be addressed by the court in view of the huge number of requests for exercise of power under Article 142 of Constitution that has confronted this court consequent to settlement arrived at by and between the husband and wife to seek divorce by mutual consent. The question are formatted here and below. What could be the broad parameter for exercise of power under Article 122 of the Constitution to dissolve marriage between the consenting parties without referring the party to the family court to wait for the mandatory period prescribed under Section 13B of Hindu Marriage Act? Whether the exercise of such jurisdiction under Article 122 not be made at all, or whether such exercise should be left to be determined in the fact of every case. Thereafter, White order dated 29/6/2016, another bench of two judges of this court on examining the question formulated in TP referred to Article 145(3) of the Constitution of India and relying on Pradeep Chandra Parija and others versus Pramod Chandra Patnaik and others accepted the submission made by the Attorney General of India to refer the question for consideration of the Constitution. It was left to the discussion of Constitution to decide whether it would be inclined to consider two questions of law indicated by Attorney General of India. The Constitution Bench, after hearing the parties why the order dated this, had deemed it appropriate to formulate another question of law which read thus under. We do believe that another question which would require consideration would be whether the power under Article Constitution is inhibited in any manner in a scenario where there is an irretrievable breakdown of marriage in the opinion of the court, but one of the parties is not consenting to the terms. Accordingly, the following substantial question of law arises for consideration before us: the scope and ambit of power and jurisdiction of this court under Article 141 of the Constitution of India. Secondly, in view of and depending on the finding of this bench of the first question, whether this court, while hearing a ratified petition or in any other proceeding, can exercise power under Article 142 of the Constitution in view of the settlement between the parties and grant a decree of divorce or mutual consent dispensing with the period and the procedure prescribed under Article 13B of the Hindu Marriage Act, and also pass and dispose of other connected proceeding under the Protection of Women for Domestic Violence Act 2005, Section 125 of Code of Criminal Procedure 173, or criminal prosecution primarily under Section 149(8)(a) and other provision of Indian Penal Code 1860. If the answer of this question is in affirmative, in which case and under what circumstances should this court exercise jurisdiction under Article 142(1) of the Constitution of India as an ancillary issue to be decided? And 3. The third issue, which is of considerable importance, is whether this court can grant divorce in exercise of power under Article 141 of the Constitution of India when there is complete and irretrievable breakdown of marriage in spite of the other spouse opposing the prayer. अब ये क्या बोल रहा है आर्टिकल 141, enforcement of decree and orders of Supreme Court and order as to discovery etc. The Supreme Court in exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice to any cause or matter pending before it, and in any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. अब ये बात कर रहे हैं, वो कंप्लीट जस्टिस की बात कर रहे हैं, मतलब उसको इंटरप्रिटिंग आउटकम दिस, अब ये इसमें इंटरप्रिटेशन की बात हो रही है, कैसे हो रहा है ये, मुझे उसको पढ़ना नहीं है. गोलकनाथ की बात कर रहे हैं, प्रोस्पेक्टिव रूलिंग की बात कर रहे हैं. Whether this decision conflict with the earlier decision of this court, including Premchand and others, exercise Commissioner AP, where 5 judges of the Constitution must have that this power under of the Constitution cannot be employed to make an order plainly inconsistent with the express statutory provision of the Constitution, of which much less consistent with any constitutional provision was examined by another 5 judges bench of the Supreme Court Bar Association and other to observe that there was no complete ratio as illustrated in of India and other. It is one thing to state that provision or limitation cannot come in the way of exercise of jurisdiction under this to do complete justice between the parties in the pending case cause of matter arising out of the structure, but quite a different thing to say that while exercising jurisdiction under of the Constitution, this court can altogether ignore the substantive provision of the state dealing with the subject and pass order concerning an issue which can be settled only through a mechanism prescribed in the statute. This observation were in the context of the power conferred on the State Bar Council under the Advocate Act, which at the first instance is empowered to decide whether an advocate is guilty of professional misconduct depending on the gravity and nature of his person's conduct. In this court in Supreme Court Bar Association of Supra has highlighted that the jurisdiction of the Supreme Court in contempt and jurisdiction of the State Bar Council under the Advocate Act are separate and distinct and are exercisable by following separate and distinct procedures. The power to punish for contempt of court rests exclusively with the court, whereas the power to punish an advocate for professional misconduct has been vested with the concerned State Bar Council and the Bar Council of India. In this context, we would like to quote the following passage from Supreme Court Bar Association. ठीक है. He must say this is as noticed in Union Carabao Corporation, draw a distinction between the constitutional power exercised by the court under 142(1) of the Constitution of India and the inherent power of the Civil Court, recognized by the Section 151 of the CPC and the inherent power of the High Court under Section 482 of CRPC, which provision empower the Civil Court in civil cases and the High Court in cases to pass such order as may be necessary to meet the end of justice or to prevent the abuse of the process of law. The expression end of justice refer to the best interest of the public within the four corners of the law, albeit the court are not empowered to act contrary to the procedure on the particular aspect of law provided in the CPC and the CRPC. Whether the CPC and CRPC are silent, the civil court or the high courts respectively can pass order in the interest of the public for the simple reason that no legislation is capable of interpreting all possible circumstances that may arise in nature in future litigation and consequently provide a procedure for them. Thus, the CPC and CRPC should not be read as to limit or otherwise affect the inherent power of the civil court and the high court respectively to make such order as is necessary for the end of justice or to prevent abuse of the power process of the court. The constitutional power conferred by Article 142 of the Constitution of India on this court is not a replication of the inherent power vested with the civil court under and high court under CRPC. Given the first background and judgment of this court, the plenary and consensus power conferred on this court under of the Constitution is seemingly unhindered, is tempered or bounded by restraint which may be exercised based on fundamental consideration or general and specific public policy. Fundamental general condition of public policy refer to the fundamental right, secularism, federalism, and other basic feature of the Constitution of India. Specific public policy should be understood as some express preeminent provision in any substantive law and not stipulation a requirement of a particular statutory scheme, which should not contravene a fundamental and not derogable principle at the core of the statute. Even in the strict sense, it was never doubted or debated that this court is the power under Article 1 of the Constitution of India to do complete justice without being bound by the relevant provision or procedure if the is satisfied that the departure from the said procedure is necessary to do complete justice between the parties. Difference between procedures and substantive law in jurisprudential term is contentious, albeit not necessary to be examined in depth in the present decision as in terms of dictum enunciated by this court in Union of India and Supreme Court Bar Association. Exercises of power under Article 142 of the Constitution of India to do complete justice is a cause or matter is prohibited only when the exercise is to pass an order which is plainly and expressly barred by statutory provision of substantive law based on fundamental consideration of general or specific public policy. As explained in Supreme Court Bar Association, the exercise of power being curative in nature, this court would ordinarily pass an order ignoring or disregarding a statutory provision governing the subject except to balance the equities between conflicting claims of the litigating parties by earning out prejudice in a cause of matter before it. In this sense, this court is not a forum of restricted jurisdiction where they decide and settle the dispute in a cause of matter, but this court cannot supplement the substantive law by building a new edifice where one existed earlier or by ignoring express substantive statutory law provision. It is a problem solver in the nebulous area. As long as complete justice required by the cause of matter is achieved without violating fundamental principles of general or specific public policy, the exercise of power and discretion under 141 is valid and as per the Constitution of India. This is the reason why the power under of the Constitution is undefined and uncatalogued so as to ensure legislative mold relief to suit a given situation. The fact that the power is conferred only on this court is an assurance that it will be used with due restraint and circumstances. अभी हिंदू मैरिज की बात करें. It's considered to be a sacred union, a devout relationship that lasts till the Hindu Marriage Act provide the right to approach the court for registration of Hindu marriage and background of decree of divorce on the ground mentioned in section 13 thereof. The provision of the Hindu Marriage Act have undergone considerable changes over a period of time. Section 13(1) was enacted by the Marriage Law Amendment 1970 to provide for divorce in cases of cruelty. Section 13(b) of the Hindu Marriage Act was introduced for divorce by mutual consent. Explanation was added to Section 9 of the Hindu Marriage Act, which resulted to restitution of conjugal right, stating that where a question of whether there has been reasonable excuse for withdrawal from the society arises, the burden of providing reasonable excuse shall be on the person who has withdrawn from the society. The effect of the said amendment, as noticed below, partially dilute the rigors of subsection 1A of section 23 of India, which stipulate that court, while examining whether any ground or grounded relief exists, should be satisfied that the petitioner is not in any way taking advantage of his or own wrong or disability or for the purpose of such relief. अब ये उनको बोल रहा है. Have living separately for a period of 1 year or more before presenting the petition, they have been able to live together. They have mutually agreed that the marriage should be dissolved. That after the first motion is passed, the couple would have to move the court within second if the petition is not withdrawn. In the meanwhile, after 6 months and not later than 18 months of the first motion, no action can be taken by the party before the lapse of 6 months in the motion. When the second motion is filed, the court is to make an inquiry and on satisfaction that the amendment made in the petition are true, a decree or divorce is granted. Clearly, the legislative intent behind incorporating subsection 2 of section 13(b) of India is that the couple party must have time to reflect and consider the decision to separate before the second motion is moved. However, there are cases of exceptional hardship where some years of acrimonious litigation and prolonged suffering, the parties with a view to have a fresh start jointly pray to the court to dissolve the marriage and seek waiver of the need to move the second motion on account of inconceivable differences, allegations, and persons made against each other and the family member. In some cases, multiple legal and including criminal cases, continuation of marital relationship is an impossibility. The divorce is inevitable and the cooling up period of 6 months, if at all, breed misery and pain without any gain and benefit. These are cases where the object and purpose behind subsection 2 of section 13(b) of the Animal Act to safeguard against hurried and hasty decision are not an issue and question, and the procedure requirement to move the court with the second motion after a gap of 6 months act as an impediment in the settlement. At times, payment of alimony and permanent lump sum maintenance get delayed, while anxiety and suspicion remain. Here, the procedure should not give way to larger public and personal interest of the parties in ending the litigation and the pain and sorrow affected by passing a formal decree of divorce as de facto the marriage has ended much earlier. Analyzing the provision of subsection 2 of this Hindu Marriage Act, this court in Amardeep Singh Harvind Kaur went into the question of whether the cooling up period of 6 months is mandatory or discretionary. It was held that the cooling up period can be waived by the court where the proceedings have remained pending for long in the court. These being the cases of exceptional situation, it was held thus. The time gap is meant to be enable the parties to coordinate, analyze, and take a deliberate decision. The object of the cooling off period is not to state the already discontinued disintegrated marriage are to prolong the agony and misery of the parties when there are no chances of the marriage working out. Therefore, once every effort has been made to salvage the marriage and there remains no possibility of reunion cohabitation, the court is not powerless in enabling the parties to avail a better option, which is to grant divorce. The waiver is not to be given on mere asking, but on the court being satisfied beyond doubt that the marriage has settled beyond repair. The judgment in Amardeep Singh refers to the several questions that the court would ask before passing an order. One way or the however, this judgment proceeds on the interpretation of section and does not examine whether this court can take on record a settlement agreement and grant divorce by mutual consent under section 13b of the Million Exercise of the Power under Article 142 of the Constitution. We must acknowledge that this court has very often entertained application prayer for divorce by mutual consent under section 13b of the Union and passed a decree a divorce without relegating or asking the parties to move a joint motion before the trial court. In such cases, other pending proceedings between the parties, civil and criminal, are appropriately dealt with in terms of the settlement and are decreed quest and closed accordingly. This situation arises when the proceedings are pending in this court against an interim or a final order passed in the judicial proceeding or on a transfer petition being filed before this court. The parties may mutually agree to dissolve the marriage, albeit on many occasions they enter into settlement often through mediation are being prompted by the court. In matrimonial matters, settlement and not litigation is the preferable court mode of dispute resolution. Exercise of jurisdiction under the Constitution of India of this court in such cases is clearly permissible to do complete justice to the cause of matter. We should accept that this court can pass an order or decree with the which a family court, trial court, or high court can pass. As per Article 142 of the Constitution of India, decree passed or order made by this court is executable throughout the territory of India. Power of this court under Article 136 and 142 of the Constitution of India will certainly embrace and ensure this power to do complete justice even when the main cause proceeding is pending before this family court, the trial court, or another judicial forum. A question or issue or lack of subject matter jurisdiction does not arise. Settlement in matrimonial matter invariably and multiple litigation, including criminal proceedings in different courts and at diverse locations. Necessarily, in such cases, the parties have to move separate application in multiple courts, including the jurisdictional high court, for appropriate relief and closure and disposal and a disposal. Thus, this put burden on the court in the form of listing paperwork, compliance and formalities, verification properly. Parties have to bear the cost, appear before several forum courts, and the final order get delayed, causing anxiety and apprehension. In this sense, when this court exercise the power under Article 142 of the Constitution, immediate assist and it is the cause of justice. However, there is a difference between existence of power and exercise of power. Of that power in a given case, existence of power is generally a matter of law, whereas exercise of power is mixed question of law and fact. Even when the power to pass a decree of divorce by mutual consent exists and can be exercised by this court under Article 142(1) of the Constitution, when and in which of the case powers should be exercised to do complete justice in a cause or matter is an issue that has to be determined independent of existence of the power. This discussion has to be exercised on the basis of the factual metrics in the particular case, evaluated on objective criteria and factored without ignoring the objective of the history provision. In Amit Kumar versus Suman Beniwal, this court has held that reading of the subsection 1 and 2 to subsection 13b of the engineering basis a total waiting period gap of 1.5 year from the date of suppression for the grant of decree of divorce by mutual consent. Once the condition for waiting period gap of 1.5 year from the date of suppression is fulfilled, it can be safely said that the period has time to ponder. The parties have time to ponder, reflect, and take consent decision, or whether they should really put the marriage to end for all time to come. This period of suppression prevents impulsive and headless resolution of marriage, allows temper to cool down, anger to dissipate, and give the supposed time to forgive and forget. At the same time, when there is a complete separation over a long period and the parties have moved apart and have mutually agreed to separate, it would be incoherent to perpetuate the litigation by asking the parties to move the trial court. This court in Amit Kumar has observed that in addition to referring the six factor questioning in Amandeep, this court should ascertain whether the parties have freely or on their own accord and without any coercion or pressure arrived at a genuine settlement which took care of the alimony, if any, maintenance and custody of children, etc. In our opinion, Section 13B of Indian does not impose any fetter on the powers of this court to grant a decree of powers on the mutual consent on a joint application when the substantive condition of the sections are fulfilled and the court, after referring to the factor mentioned above, is convinced and of the opinion that the decree of divorce should be granted. The legislature and the court treat matrimonial litigation as a special, if not unique, category public policy underlying the legislation dealing with family and matrimonial is to encourage mutual settlement as to clearly stated in Section 89 of the CPC. Section 23(2) of Hindu Marriage Act and Section 9 of the given that there are multiple litigation governing different aspects, even if the cause of dispute is identical or similar. Most matrimonial disputes lead to a miscellany of cases, including criminal cases, at times genuine and other occasion initiated because of indignation, hurt, anger, or even misguided advice to teach a lesson. The multitude application can restrict and block solution. The settlement has to be holistic and comprehensive, given that the objective and purpose is to be enable the parties to cohabit and live together, or if they decide to part away, to have a new beginning and settle down to live peacefully. Therefore, in B.H. Joshi and others, state of Haryana, this court, notwithstanding the section does not permit compounding of an offence under 49 of this has held that High Court exercising power under may face prosecution even in non-compoundable offence when the justice so required. This view has been affirmed by the three-judge bench in Gyan Singh versus State of Punjab and others, and reiterated by another three-bench judge in Jitendra Raghuvanshi and others versus Bhavita Raghuvanshi and another. The reason is that the court must not encourage matrimonial litigation and prolongation of such litigation is detrimental to both the parties who they are engaged in chasing multiple litigation. Thus, adopting a hyper-technical view can be counterproductive as pendency itself causes pain, suffering, and harassment, and consequently, it is the duty of the court to ensure that matrimonial matters are amicably resolved, thereby bringing the agony, affliction, and torment to an end. In this regard, the court may also have to inquire and ensure that the settlement between the parties is achieved without pressure, force, coercion, fraud, misrepresentation, or undue influence, and that the consent is agreed sought by free will and choice, and the autonomy of the parties is not compromised. The latter two decisions, Gyan Singh and Jitendra Raghuvanshi and others, observe that relevant inherent power of the High Court under Section 482 of the CRPC is wide and can be used wielded to quash criminal proceedings to secure the end of justice and prevent abuse of the process of the court, albeit it has to be exercised strongly, carefully, and with concern. This court in the state of Madhya Pradesh, Special Examination and others has set out guidelines as to when the court may exercise jurisdiction under the inherent power conferred under Article 482 of the CRC for quashing non-compoundable offence in terms of Section 320 of the CRPC in view of the above legal position and discussion. This could on the basis of settlement between the parties while passing a decree or divorce by mutual consent can set aside and quash other proceedings and orders, including criminal cases and first information report, provided the condition as required in the aforementioned judgments are satisfied. Grant of divorce on the ground of irretrivable breakdown of marriage exercise of this. This brings us to the last question of whether this court in exercise of power of the Constitution grant a decree of divorce when upon the prayer of one of the parties declares that there is complete and irretrievable breakdown of the marriage, notwithstanding the opposition to such prayer by the other spouse. अब ये सेक्शन की बात कर रहे हैं. Three judge bench of this court, after referring to the provision of the Indian Evidence Act, held that the fact is said to be established if it is proved by a preponderance of probability, that is, the court believe it to exist, consider an existence of survival that pregnant man ought to, under the circumstances of a particular case, act upon the supposition that it is often the belief regarding the existence of act is founded or balance of probability. That is, the court is to weigh on various probabilities to discern the preponderance in favor of the existence of a particular fact, holding that the proceeding under the Hindu Marriage Act are civil proceeding and referring to the provisions of Section 23 of the Marriage Act. It is held that the word satisfied must connote satisfaction on preponderance of probability and not beyond reasonable doubt on the meaning of the probability as a ground of resolution of marriage. Reference was made to the High Court reliance on D. Tolstoy's passage, the law and practice of divorce and matrimonial causes. Therein, cruelty has been defined as willful and justified conduct of such character as to cause danger to life, limb, or health, body, or mentally, so as to give rise to reasonable apprehension of such danger. However, this court felt that the Tolstoy passage was, which cites Horton is not enough to show that the spouses find life together impossible if there is result injury. Accordingly, this court illustrated that if the danger of health arises merely from the fact that the spouses find it impossible to live together and one of the parties is indifferent toward the other, change of cruelty may happen. The charge of cruelty may happen, perhaps fail. However, harm or injury to health, reputation, the working career of the like, or the like would be important consideration in determining whether the conduct of the defending spouses amount to cruelty. The petitioner has to show that the respondent has treated them with cruelty so as to cause unreasonable apprehensions in their mind that it will be harmful or injurious to live with the contesting spouses. In today's context, two observations while a court inquire into the charge of cruelty are of the some significance, but the court should not specify on the modalities of married life. Secondly, whether the charge is proved or not cannot be decided by applying a principle or whether a reasonable man situated similarly will have behave in a similar manner. What may be cruel to one may not matter to another, and what may not be cruel to another individual under one set of circumstances may be extremely cruel under another set of circumstances. Cruelty is subject to, that is, it is person background and circumstances specific. इसमें ये बोला है, इसके बाद अशोक कुमार में ये अशोक हुर्रा रूपा बिन जावरी डिसाइडेंस में ये बोला है, नवीन कोहली वर्सेस नीलू कोहली 3 जजेस में ये बोला है, सुप्रीम कोर्ट in this instance, this court exercised the power under Article 142(1) of the Constitution of India, recognizing the utility of completely failed and broken down marriage while observing that there was no consent of the respondent wife for grant of divorce. The court felt that there is no willingness on her part either to live with the plaintiff husband. What were left in the marriage were better memories and angst, which increased with the passage of time, as the respondent wife was reluctant to let the appellant husband live his life by getting a decree of divorce in view of the aforesaid position. This court exercised the power under Article 1 of the Constitution to do complete justice between the parties. It was also directed that the appellant husband would continue to pay the to pay the specified amount per month to the respondent wife, which amount would be enhanced or reduced by taking recourse to appropriate proceedings. फिर ये इसकी बात कर रहे हैं. Having said so, we wish to clearly state that grant of divorce on the ground of irretrievable breakdown of marriage or by this court is not a matter of but a decision which is to be exercised with great care and caution, keeping in mind several factors ensuring that complete justice is done with to both parties. It is obvious that this court should be fully convinced and justified that the marriage is totally unworkable, emotionally dead, and beyond salvation, and therefore resolution of marriage is the right solution and the only way forward. That the marriage has irretrievably broken down is to be factually determined and firmly established. For this, several factors have to be, such as the period of time the parties have committed after marriage, when the parties have last committed, the nature of allegation made by the parties against each other and their family members, the order passed in the local legal proceeding from time to time, cumulative impact of on the personal relation, whether and how many attempts were made to settle the dispute by intervention of the court or through mediation, and when the last attempt was made, etc. The period of separation should be sufficient, and anything over 6 years or more will be a relevant factor, but these facts had to be evaluated keeping with the economic and social status of the parties, including the educational qualification that the parties have, and children, their age, educational qualification, and whether the other spouse and children are dependent, in which and how and in what manner the parties seeking divorce intend to take care and provide for the spouse of the children, question of custody and welfare of minor children, provision of fair and adequate alimony for the wife and economic right of the children, and other pending matter. In any of the relevant factors, we would not like to codify the factors so as to curtail exercise of jurisdiction under which is a situation, especially some of the factors mentioned can be taken as illustrative and worthy of consideration. Toward the end of for the sake of completeness and to avoid confusion and debate on the ratio we have expounded, we would like to examine a few decisions in which this court has refuted such a reduction of the Constitution. India are dispensed with period of 6 months for moving the second motion in the division bench of this court has held the power of jurisdiction under Article 8 of the Constitution. Though couched with the wildest possible terms and plenary in nature is discretionary, thus the extraordinary care and caution must be exercised unless it is shown that exceptional and special circumstances exist to demonstrate that substantive and grave injustice has been rendered. This court should not interfere with the decision appealed against. Article 136 of the Constitution should not be used to short-circuit the legal procedures prescribed. The power under Article 142 of the Constitution of India was summarized to observe that the court would not pass an order in contravention or ignorance of historic provision or merely on systematic ground. However, the bench did not specifically examine the question of whether the period prescribed under the is mandatory or directory in nature, and if directory, whether the same would be dispensed with by the High Court in exercise of the writ appellate jurisdiction. Further, the two judges bench did not exercise extraordinary jurisdiction under one particular of the Constitution, observing that it was not a case whether there was any obstruction or to the stream of justice or there was justice to the parties, requiring the court to grant equitable relief. The contingencies to exercise a power under one particular of the Constitution were not established. नीतीश भटनागर वर्सेस दीपक भटनागर, ये हो गया. उसके बाद में क्या बोल रहे हैं? Sham Sundar Kohli versus Sushma Kohli alias Satya Devi. The bench has refused to grant divorce on the ground of irretrievable breakdown of marriage. That only in extreme circumstances would this court in Darshan Gupta versus Radhika Gupta, the ground of rivalry and not reflected. Therefore, the two judges bench on the examination of this observed that it is founded on the matrimonial offense theory or fault theory. अच्छा चलो ये भी हो गया. उसके बाद इन Neelam Kumar versus Dayarani reference was made to Satish Sitole and versus Ganga when the marriage was dissolved in exercise of the power. 38 chapter खत्म. In judgment, Savitri Pandey versus Prem Pandey referred to the suggestion in which the two judges bench had suggested a complete reform of the law marriage. अच्छा ये भी हो गया. In view for finding recorded, we are of opinion that the decision of this court in Manish, Neelam, so and so, and others have to be read down in the context of the power of court given by the Constitution of India to complete justice exercise the jurisdiction under 141 of the Constitution. In consonance with our finding on the second scope and ambit of this, we would have power to do so. Complete justice is not fettered by the doctrine of fault and blame applicable in petition for divorce under section 31 1 1A of the Hindu Marriage Act as held above. This court power to dissolve marriage on settlement by passing a decree of divorce by mutual consent as well as quash and set aside other proceedings including criminal proceedings remains and can be exercised. Lastly, we must express our opinion on whether a party can directly confess before the court the ground of irretrievable breakdown by filing a petition under Article 122 of Constitution in Poonam, so and so the judicial bench of this court has rightly held that any such attempt may be spurned and not accepted as the parties should not be permitted to file a petition under the Constitution or for that matter Article Constitution before the High Court and seek divorce on the ground of irretrievable breakdown of the marriage. The reason is that supremacy of the person aggrieved by the decision of the competent jurisdiction forum is to approach the superior tribunal forum for dismissal of his grievance. The parties should not be permitted to circumvent the procedure by resorting to the retribution of the Constitution, as the case may be. Secondly, and more importantly, relief under 130 of the Constitution cannot be sought to enforce the right conferred by Part 3 of the Constitution and on the proof of infringement thereof. The judicial order passed by this court in or in relation to the proceeding pending before it are not available to correction under Article 133 of the therefore. A party cannot file a writ petition under the Constitution and seek relief of dissolve of marriage directly from this court. While we accept the said view, we also clarify the reference to and the observation that is questionable whether a period of 6 months for moving the second motion can be waived has been approved by his conclusion. In view of the aforesaid question, we decide reference by answering the question framed in the following manner. This question has to be the answer to the court of the Constitution is answered in terms of paragraph 8 to 13 entirely holding that this court can depart from the procedure as well as the substantive law as long as the decision to exercise based on consultation of fundamental general and specific public policy while deciding whether to exercise jurisdiction, this court must consider the substantive provision as enacted and not ignore the same. Albeit this court act as a problem solver by balancing out equities between the conflicting claim. This power has to be exercised in a cause of matter. In view of and depending on the finding of this bench on the first question, whether this court, while hearing a transfer petition or in any proceeding, can exercise power under these of the question of the settlement between the parties and grant a decree of divorce by mutual consent, dispensing with the period and the procedure prescribed under 13B of the 100 and also pass and dispose of other connected proceeding under the Domestic Violence Act 135 of the CRPS criminal prosecution, running under section 14090 of the Constitution. If the answer to this question is in the affirmative in such cases, under what circumstances should this court exercise jurisdiction and under this one? देखो सिर्फ भी affirmative अच्छा ये हो गया ये भी affirmative में हो गया whether this court can grant divorce on exercise of power of this marriage. This question is also answered in affirmative inter holding that power this had education to resolve the marriage on the ground of irretrievable breakdown. The decisory power is to be exercised to complete justice to the parties where this court is satisfied that the fact is established. अच्छा. From the following region, transfer petition of this are disposed of as wide order dated 6th division bench of this court has already resolved the marriage between the parties by invoking Article 29 of the Constitution. Transfer petition must be listed before the regular bench in the second week of May for approved order and direction. Sanjay Kaul, Sanjeev Khanna, Abhay Oka, Vikram Nath, J.K. Maheshwari, New Delhi, May 1, 2023. तो ये था आपका सुप्रीम कोर्ट का ऑर्डर. अब यहाँ पर यह बताना जरूरी है कि सुप्रीम कोर्ट ने अभी कुछ दिनों पहले एक और ऑर्डर दिया था जिसमें उन्होंने बोला था, मैं बताता हूँ आपको, फिर से बताता हूँ. क्रूरल्टी के ऊपर कोई जजमेंट दिया था वो couple living apart for 25 years seek divorce. What Supreme Court said? The Supreme Court said the complete severance of all meaningful ties and existing bitterness between the two should be read as cruelty under the हिंदू मैरिज एक्ट. ये बोल रहे हैं सुप्रीम कोर्ट. ये है 27 तारीख का, 27 अप्रैल का ऑर्डर है. अच्छा भाई, Supreme Court has dissolved the marriage of a couple who have been staying separately for 25 years, saying recognizing them as married would be sanctioning cruelty. The couple only lived together for 4 years. A bench of Justice Sudhanshu Dhulia and J.P. Pardiwala said the complete severance of all meaningful ties and existing bitterness between the two should be read as cruelty under the Marriage Act. We have before us a married couple who have been together as a couple for only 4 years and have been living separately for the last 25 years. They do not have children and their marital bond is completely broke beyond repair, the Supreme Court said. We have no doubt and because its continuation would be to sanction cruelty, prolonged separation, absence of provision, complete appearance of meaningful ties and existence, bitterness between the two should be read as cruelty under the Hindu, the Supreme Court said. It said the ending of this marriage will affect only them since they have no children. The man makes more than 1 lakh a month and he has to pay 30 lakhs to the woman within 4 weeks, the Supreme Court said. The couple got married in 1994. He alleged he had an abortion the same year without telling him. He alleged he did not like their house as it was small. 4 years into the marriage, the woman left and filed a case of delivery harassment against him. The man and his brother were arrested and later released on bail. He filed for divorce after that. The trial court allowed the divorce petition on the ground of cruelty and long separation, but the High Court rejected the divorce because after which the man challenged the High Court decision in Supreme Court. ये था. तो आपके सामने मैंने ये पढ़ दिया है. अब ऐसे ही आगे भी अगर कोई इम्पोर्टेंट जजमेंट आएगा तो मैं आपके सामने लाता रहूंगा और आपको कानून के बारे में अवेयर करता रहूंगा, क्योंकि मैं इसे अपनी ड्यूटी समझता हूं कि आप लोगों को भी कानून के बारे में मालूम होना चाहिए. ठीक है, तो मिलते हैं अगले किसी और वीडियो में. तब तक के लिए नमस्कार, धन्यवाद. आप अपना ख्याल रखिए. जय हिंद, भारत माता की जय, वंदे मातरम.